Thank you all for joining today's class. And I'm really excited to share my knowledge with you. And I hope it's for everybody very interesting. Even if you don't operate a business yet, I think it's important for you because you learn what you should be aware of. So during this lecture, we will basically continue with what we discussed last time. But I will first start with a recap. So even if you did not attend the last lesson, you can still follow the content. So last time we spoke about signing business to business contracts and we were navigating common pitfalls. So what does that mean basically? We learn from the most common mistakes here. So first we will explain what is a business to business contract? Who does it even apply to? What should be considered a business to business agreement? And then afterwards we're going to discuss a lot of different questions so you can feel how a business to business contract works in practice. And then you can think of the specific answer or maybe mistakes other people made so we can all learn from it. So first of all, I'd like to welcome everyone, and I want to make clear that the information I share with you today, it can differ per jurisdiction, of course, because every country, they have their own laws and regulations. So it's more meant for informational advice. Last time we discussed almost everything of the business to business agreements, but we will start with a brief recap today. So in our last lecture, we basically discussed what is a business to business agreement, right? So what is the key concept and what are the most common pitfalls? So we explored the biggest fundamentals of the business to business contracts and the nature and the purpose, because a business to business contract is different than when you sign with a consumer, because they have different laws applying to business agreements and there are different laws applying to a business to consumer agreement. A consumer most of the times is more protected because they are not a professional party. They are a natural person, for example. A business to business contract is between entities, so a legal entity, and they should contain some critical contract elements. And there are common pitfalls to avoid in any business to business agreement. So let's start today with a quick recap of the most important points we discussed last time. And if you have any questions at the end of this lecture, we will have time to discuss your questions. But you can also raise your hand meanwhile, and then Dr. Lambert can help me to answer the questions during the lecture to make sure you all understand the information here. So the first topic last time we discussed what is the definition of a business to business contract, followed by the main purpose. Why do we even need a business to business agreement? What's the relevance? Maybe I can sign as a natural person instead of through my entity's name. Why is it so important to know what should be included in such an agreement? The key elements. And we will discuss interactive questions. So first, I would like you to think for a minute about the definition of a business to business agreement. Does any one of you have an idea what makes a business to business agreement different than when you sign with a consumer? What would be the biggest difference here? You can put in the chat your thoughts so I can see them. I think we have some answers coming in a bit. There are actually quite a few major differences we can think of. Perhaps some of you already signed such an agreement. If there are no answers, I will proceed. So the definition here of a business to business agreement is basically that it's signed between two entities. This is the biggest difference, of course, which speaks for itself. It's a binding agreement between two entities. So even if you are setting up a company, if it's not created yet and it's not registered in the trade register, there is not maybe a company or a representative of the company authorized to sign from the company's name. So it should be a legally binding agreement between two companies that are incorporated, existing. So this is really important to check. You can always check any company in the trade register of the country they are registered in, and you can check their activities as well and their full name. So a business-to-business agreement should outline the terms and conditions of the relationship between the two companies, the entities, and it should detail what each party is expected to deliver under the agreement and receive. Because if you are going to start a new collaboration, for example, I have a company in the UK and I want to hire a market agency in the States, for example, to get a bigger target audience, right? We need to know clearly throughout the agreement what we can expect of the other party. What are the rules? Can we define them? For example, they're going to publish, for example, 20 advertisements per week in this type of format. They're going to reach out to these specific customers. What are the payment terms? What happens in the event they do not pay on time? And what can they expect from me as their client? What type of information am I supposed to provide to them so they can work with me, so they can work with my company in this scenario? So it's really important to define the roles of both parties involved in the agreement, the activities, who is going to deliver what under the agreement, are you going to pay for the services, what will happen in the event of non-payment, and also if it's a cross-border relationship, then we have to think about some additional aspects, but we will discuss this in a bit. So the purpose of a business to business contract is to establish a clear framework, right? So we can have a transaction in a clear manner and there is not going to be any argument, hopefully, about it, because they can help to prevent misunderstandings by put down in writing what you can expect from the other party, especially if you think you know the other party personally. People often tend to forget to put down things in writing, and then there's a high risk of a dispute eventually because maybe it wasn't really clear what was the responsibility of the other party. Was there a specific timeline that we agreed upon, or maybe a deadline to deliver project A, because we need to proceed with project B as well, or maybe they're going to deliver a code base under the agreement. When is it going to be finalized? It's really important to define as much as you can under the agreement the terms that are applied and what you can expect of the other party. So if there are critical aspects that govern your business relationship, make sure to include them and also think about the risk. So for example, if you're going to work with another company, what could be the biggest risk for your company when you enter into this relationship with the other party? This can differ per industry, but you also have to think about liability. For example, who is going to be liable in the event there is going to be uh, for example, a leak of confidential information, or what are you going to do if the project is not being delivered as the parties have agreed upon? For example, when it's a construction company, this could be really important. So the purpose here is to protect both parties and to have a better understanding what you can expect from each other and to make a better informed decision eventually, because you know what to expect and you can create a more long-term relationship because there is less room for misunderstandings. So why do we need mutual intent in a business-to-business contract? Does any one of you have any idea why is it so important to both agree on the terms and conditions? Why is this an aspect that is actually required to check if there is even a contract?
So the question is why is mutual intent to enter into the contract a necessity, a requirement? Is that the question?
Yes, that's the question, correct.
So why is that important? You can write your answers into chat.
So I see a comment here. Two organizations coming together to collaborate. Yes, that's true. But also, if we think about, for example, if you get an offer from a company, does that mean there is a contract yet? Can you hold the other entity liable here? Or what do we need specifically?
Lynette, I have a question. If somebody signs the contract, doesn't that just imply their willingness to go into the contract? Or do you have to
Yes,
prove
that's
that somehow they were
signature.
Or do you have to prove that somehow they signed under duress or pressure?
No, if it's signed under pressure, so for example, if somebody is being threatened, we will discuss this actually during this lecture in a bit. That's something you have to prove that it was forced, and then the agreement can become unenforceable because it was illegal. If somebody signs the agreement and this person is authorized to sign, there is mutual intent. But we speak about mutual intent because if there is only an offer, but it's not accepted by the other party, there is no mutual intent. So both parties need to agree upon the terms. So if only one person intends to enter into an agreement, that's not sufficient. Both parties need to be willing to enter into such a relationship. That's why it's important because it's basically protecting both parties. So it ensures that parties are creating something that is legally binding. So a document that is signed by both parties is legally binding because it has a signature. But if somebody, that's why you raised a really good point, Dr. Lambert, if you are threatened, for example, if you are a minor, the legal framework does offer protection to such uh, groups of people or scenarios, unfortunately, because if you are not willing to enter into an agreement or it's about illegal activities, it should not be enforceable. And a minor is not even somebody who should be capable of signing such an agreement because they are a minor and they are protected by the book of law. So that's why a mutual intent should be applicable. And if you are being threatened, then you did not intend to enter into the relationship because you were forced to enter into the relationship. So it cannot be legally binding if you can prove this. So it's really good. I think that the legal framework does offer protection here. And this is something that is required to check if there is even a contract applicable in your case. So what happens if a contract is for an illegal purpose? We just answered this question, but the contract becomes unenforceable because it's illegal. So for example, if I'm going to sign a contract to deliver weapons, and I am not a entity that is that has the permission to sell weapons, for example, or maybe you do something with like spy gadgets, whatever, and it's not legally allowed, then the contract might not be enforceable. So it's going to be more difficult if you sign such an agreement to enforce your rights because the contract itself was never legally created. So even if you're going to sign such a contract, if it's not fulfilled, so for example, if one party is in breach of the agreement and he is not performing according to the illegal agreement, it's going to be difficult to make it enforceable because it's not legal. So this is always important to check. And other key aspect here is to verify the identity of the signatory. So for example, if you're going to sign with another party, what do you think could be a problem here if the person says, I am representative of this hotel, I will sign according to the hotel, and you didn't check anything? What could be a risk here? Does anyone have any idea? Rose, you raised your hand. I'm not sure. Can you ask the question or should I unmute you? I think there we go. Dr. Lambert, we have one question here.
Okay, Rose, I think we can hear you now.
You have to, I mean, ascertain the identity of the signatory to identify the legal capacity of that person. Because it may happen that he doesn't even have the capacity to enter into that contract. So if you enter, you don't find his identity, the contract can become void. Though it has gone to a far extent, but since it is void, you cannot hold him responsible because he doesn't have the legal capacity.
Yes, Ross, I think the connection is not really good, so I can hear you half. I think you are saying that it's important to check the identity because we have to check if this person is authorized to enter into the agreement. Is that correct, Dr. Lambert?
Yeah, that is the legal capacity
Yes.
of the signatory must be ascertained.
Okay, Rose, otherwise perhaps you can ask your question in the chat so I can read it. But what you say is very correct. It's important to check the identity of the signatory, not only to check if this person is allowed to enter into the agreement, but also, for example, if I am going to buy a house from a company and this house is, let's say, 1 million, and this person is stating that this person is authorized to sell the house to my company. If I didn't verify the identity, but I did transfer the money to the company, it's going to be more difficult to enforce my rights under the agreement because the company never entered into the agreement with me. It was a person who was falsifying his or her identity. So basically committing fraud. Rose, can you maybe put yourself on mute? Yeah, but it's going to be very difficult to enforce your rights or even to fight for justice because if somebody is going to commit fraud and you don't know if this person is actually authorized to enter into an agreement or to act on behalf of this entity, then it's not going to be enforceable against this company because this person was never authorized to start such a relationship with your company. So it's really important. So that's why also, for example, if you enter into a tenancy agreement, the real estate agent will ask you a valid copy of your passport. It's also important to check who are the shareholders of a company. Is it only one shareholder who is the ultimate beneficial owner of the company? This is important to be aware of. And you can always ask for a valid copy of the trade register, but you can check if the company is existing in the trade register, because if it's an active company, you can check by searching in the database of your own country. You go to the trade register and you can always check the company's number, the company's address, when it got incorporated, and you can see some information about the status. So always ensure you are dealing with the right person and check if this person is actually authorized to bind the company you are going to work with to prevent fraud. So it's always important to check a bit of information of your customer because you need to know who you're going to be working with, especially if it's going to be about a lot of money. So another aspect we can think of are how do payment milestones benefit both parties in a contract? So if we think about payment, so if we work with another company and we are going to deliver a project, so for example, we're going to create a design and they are going to pay for us and it's going to take us 6 months to create the design, we could ask for a one-time payment, but we can also ask them to pay in different milestones. So for example, milestone number 1, milestone number 2, and milestone number 3. Why do you think this could be beneficial for both parties involved here? What do you think could be beneficial when we enter into an agreement that mentions we will get paid with milestones? So we get paid in portions. I'm going to give you 1 minute to think about this question, and I would like to hear one example per party. So one example for the client, who is hiring the service provider, and the service provider who is going to create the design, for example, or a design company. What could be the benefits for him? So if I will deliver a design to my clients, why would it be better for my client to have milestone payments, and why for me as the delivering party? I'm eager to hear your answers. I'm going to give you 1 minute from now to think about the question. If you have an answer already, please answer in the chat so we can discuss it all together. I see one answer, which is very correct. It will help to ensure legal validity and accountability. Yeah, correct. Because it could be more trustworthy. It lowers the risk of suit, also correct. Anybody else would like to share their thoughts here to avoid delay? Also really good answer. For commitment. Yeah, they're all good answers. It's really important because what could be the biggest risk here if we agree upon only one milestone? The biggest risk here is to not get paid at all. Because if there is only one milestone, that could be the biggest risk. If there is not going to be paid anything upfront or upon signing the agreement and you will deliver the entire project, you might not get paid for the project. So it's always better to have a few milestones if you're able to agree upon a couple of milestones instead of only one. Also for the client, it will give more trust because he knows that he can pay in different periods. So it will create more cash flow for you if you're going to deliver because you will get paid through installments, for example, in milestones. But you will also be more trustworthy for the client because you keep working on the project. And also, if there's money invested, if you need to invest money, this way there is always a return as well. So, for example, if a construction company is selling a off-plan house, they usually also get paid in milestones, for example. So they keep the money flow going, right? So if they receive money, they can keep going and they can continue to build. So sometimes if you proceed with milestones, it creates a certain cash flow and more certainty. So for both parties, it could be very beneficial. Another question I would like to discuss with you today is what is the risk of skimming a contract instead of reading it thoroughly? So there are multiple risks we can think of. One of the most important one is if we think about skimming through a contract and we're not going to read it thoroughly, section per section, we can miss important clauses because you can overlook the details, and this can lead to unforeseen commitments or even costs. Sometimes people think an agreement is basically copy paste per profession or per industry, but this is not how it works. It should be tailored to the scenario and to what the parties have agreed upon, and it should be compliant per jurisdiction as well. So, for example, if you're going to agree on any penalty provision, I really recommend you to be careful here. What are your commitments under the agreement? Check if you are able to deliver under the agreement. Are these commitments realistic for you? What happens under the agreement if you are not able to deliver? What does the other party expect from you? Also, always check the deadlines. And some agreements, they can be renewed automatically. If an agreement is renewed automatically, it can be a good thing because then you don't need to think about the negotiations, but it can also be not the best thing because there's less room for negotiations because it can renew automatically. So if it's a really important agreement, for example, and it's going to be the first time you're going to work with the other party, it could be valuable to not sign a 5-year contract, for example, or an automatic renewal contract, because maybe you didn't know what to expect after the first year when you signed the agreement. So maybe you would like to have more space later on after the first year to review the commitments, the costs or the payments, or perhaps the activities even. So maybe you would like to renegotiate the content of the agreement and you do not want the agreement to renew automatically because sometimes people forget. And if it renews automatically, you might have an argument about this. So think about the party you're going to work with. Is this somebody you know? Is it somebody you can trust? And what do you think could happen after the first year? Is there going to be a different scenario, perhaps applicable? Or would you like to renew automatically because you have done such a big investment in this relationship? Automatic renewal could be actually beneficial. So it's really important to check per type of relationship. What do you think is going to benefit you and the other party in the best way? So another question for you is to think about a consideration in a B2B contract. What is a consideration? We discussed this last time. Does any one of you still remember what is a consideration? Does anyone still remember? It's very typical for a business-to-business contract. Terms of payments. Almost getting close. I will help you. It could be something that's going to add value, and it's something which should be in any contract, because you are going to deliver, or one party is going to deliver, and the other party is going to, for example, put something on the table to give back for what has been delivered to you. So basically, it means it's a part of an exchange within the agreement. So one party is going to create something for the other party, and the other party will pay for this. So the consideration basically means it's going to add value. It doesn't need to be something of cash at all times. It can also be services. So it can be a promise, a performance. It's something that's going to add value to the agreement. And a consideration must provide value to both sides in order for each party to agree, because both parties will agree on the added value under the agreement. Because you're not going to work with a party without any reason, right? There's a reason why you would like to enter into this relationship. So what is it that's going to make you desire to start the relationship with the other party, and what's going to be promised or performed or delivered? So it can be many different things, but it's something that adds value. So think about services or cash, for example. Last time we
Just
also
a quick question, Lynette. Are
yeah.
milestones based on considerations?
Milestones, well, they could be based on consideration, because it's something that's adding value, like money, right? Because they're going to pay for it. So it's adding value. But milestones specifically, it's more a way of how it's going to be paid under the agreement, because there are different ways. So for example, if it's a long-term relationship, you can, for example, agree upon 20% payment before you will start performing. So for example, if you will create a kitchen, sometimes they would like you to pay in advance because they need to build the material as well, or they need to buy the material. And then, for example, another 30% will be paid when you're at stage 2, and then the final payment will be done when it's actually completely finalized. So milestones could bring you a lot of protection for the parties. That's why milestones, I think, can be very valuable, because it will bring value to both parties and they also agree on this. So it's a consideration because it brings value to both parties and they have agreed on this, but it doesn't need to be milestones because it can differ per contract. And if it's a small task, for example, then you can agree upon like a down payment or a one-time payment. It depends on the activities and the performance under the agreement, what is the best for the parties to agree upon, what will create the least amount of risk for you. Because if the other party will not pay, it might be very difficult to actually retrieve the money, because if the other company doesn't have the money, for example, it's going to be very difficult. And if you created something very valuable or you invested a lot of money, yeah, then it could be a huge risk for your company. Did I answer the question, Dr. Lambert, or?
Oh, yes, absolutely. Yes.
Okay, great. So last time we also spoke about defining the governing law, and I think, especially because the Atlantic International University is so global, I think it's really important for all of us, hopefully today here, to think about cross-border agreements as well. because nowadays we notice that everything becomes much and more digitalized, right? So it's much more easy to start a relationship with a party in a different country, or we can order from Amazon basically whatever we want. Or you could maybe hire a company for marketing from the States. It's more easy nowadays to find a company because of the internet, and we are more we have more access to different sources. So it's really important to think about the governing law, because if one company is based in the Netherlands and the other company in France, then what do we do in case of a dispute? Right? It's important for the parties to agree on this, because you cannot just pick any governing law. It needs to make sense. So usually it's the country where one of the entities is based in. There needs to be a link to the governing law. Because if I would, for example, say that the Italian courts are going to handle the dispute, they're not going to handle the dispute, because it doesn't make any sense, because my company would not be located there and neither of the counterparty. And it's going to be very expensive for both of us. So what can we do here if it's a cross-border relationship? We can think about different things. So we can think about mediation, for example, in the event of a dispute. This is a neutral party. And usually both parties, they share the costs together. You can also think about arbitration. This is also final and binding, and it can go faster, and sometimes they also conduct remote hearings. Usually the governing law is something that the parties decide upon together, but it should be one of the jurisdictions in one of the countries where one of the entities is actually based. So it should make sense under the agreement. And also, I'd like to discuss with you today, like if we speak about trade secrets, if you have your own company, a trade secret is really important. So what is a trade secret? It basically creates the more competitive edge for your company. So it's something more unique. You have some specific information that gives you value to be a competitor in the market. So if you are going to sign an agreement and your company has a trade secret, then what would you put in the agreement to have more protection? Because if I'm going to work with a marketing company, I might have to share with them some business information, or maybe specific data, or maybe information about my products. And they could steal this information and create a similar product. Perhaps this could be a risk. So what type of clause would we put in such an agreement to protect ourselves at a minimum? I see we have one answer here, a non-disclosure agreement. Yeah, a non-disclosure agreement is actually a specific type of agreement, but it's a good answer, that says that you're not allowed to share the confidential information with anybody else that's being shared between the parties. So it's a good answer, but this is a other type of agreement. But you can also sign a non-disclosure agreement, because that means that you will treat all confidential information as confidential between the parties, and you are not going to discuss this with any other party outside of your relationship, unless required by law. So for example, if the tax authorities or the government require more information from you, you should give them the information, even when it's confidential. So what we can think of is a confidentiality clause. And this is also something we see in a NDA agreement. An NDA is a non-disclosure agreement. So be aware of a very broad scope, because not all information that is shared by the company is usually confidential, right? So I mean, if I will share with you company information, not any and all information I'm going to share with you is deemed confidential information. If I will say, for example, that even after the termination of our agreements, you should keep any and all information confidential, this might be a too broad scope, because not any discussion I had with you was perhaps confidential. So check if the scope of confidential information is actually something that is sensitive. and try to define it as much as you can. The type of information that matches the type of entity. What type of information can you expect to share between each other, and what type of information do you even need to start the work? Perhaps I do need some information of you to perform the activities. So, for example, if I have a construction company, I might need to know specific building details or other sensitive data, but not all information usually is confidential. So be aware if the scope is not too broad, and also check if the term is not unreasonable. So, for example, if they say it's going to be enforceable indefinite, even after termination, check if this is reasonable, because it might be too harsh on you. It should not be a burden. It should be reasonable and fair. So, why would you, as a company, engage a legal professional for a contract review? Well, first of all, to ensure compliance, right? Because they know what book of law actually applies in your jurisdiction. They should be aware of the articles. They should stay up to date of the legislation or any changes that might be enforced soon. And they can provide you clarity about the contract, so they can inform you, being a professional, about the legal standards, what you can expect. So, for example, some provisions would be more reciprocal and not too single-sided, because that could be deemed unreasonable. They can refer to specific laws, regulations. They can think of precedents. They can think with you about the risks as well, and to protect you better, because they work with contracts full time. So if you would ask them to review a contract for you, they can inform you better about the risks. And if you are going to read it by yourself, you might not be fully understanding the legal words or the definitions. So in case of any question, I do recommend you to seek legal experts and check what governing law is applying to the contract, because that law should be governing the agreement and the terms and conditions. So what can happen if an entity signs a contract without any authority? This is something we just discussed, but the contract may be invalid. So you have signed something that might not be enforceable because the other person perhaps did not have the power to actually bind the entity. So if I'm going to sign an agreement on behalf of Hotel X, but Hotel X never authorized me to have such a decision-making authority, I'm not even able to bind the hotel. And this is very important, because if there is no authorization, the whole contract might not be valid. So it's really important to check if this person is authorized, because only then they can actually bind the entity. And even if it's an entity, for example, what do you do if it's a group of entities, or maybe it's a subsidiary of a company? Check which entity is capable of entering into the agreement. So now I have a question for you. Like, what do you think if we have unclear delivery terms? How can that affect a business? So, for example, if there are not very specific terms for delivery, or maybe the other party, business A, delivered not on time, are we allowed to suspend payment here because there are not very clear terms? What do we do here? What could be a problem and what could be a solution? Do you think you are allowed to suspend payments if the other party is not on time with delivery? It's important to think about this, because if the agreement lacks clarity, there's going to be an argument between the parties. So you can suspend payments, but it might create an extra argument, because maybe the party did not deliver on time, but it was beyond its control. Then what do we do now? for example. So maybe a boat will deliver the shipment, but the boat maybe had a problem, or they um, they were delayed because of problems with customs. Then are we allowed to suspend payment here when the company actually did deliver the product on time to the boat, to the shipping company, for example? It depends on the contract, because if you're going to suspend payment, if the company did deliver, but they have trouble, then sometimes the client who paid for the product could be liable, because sometimes when a product is being shipped, the risk will go to you. So it depends on the type of agreement and the terms that you agreed upon with the other party. If there is damage to the goods, I see a question here. If it's damaged, then you can send back the product to the company, but it depends on how the damage occurred. If it's because of shipment, there should be an insurance applicable. If it's a big company and if your goods are delivered malfunctioning, for example, you should have warranty, first of all. If it's damaged because of the shipment, you can ask for a new product as well, but it always depends on the agreement and the terms and conditions. Usually a big company, they have the terms and conditions, but this is more business to consumer. They have the terms and conditions always uploaded on their website, because a customer should always be able at all times to review and read the terms and conditions. It should always be easily accessible as well. If it's difficult for you to find the terms and conditions, they can be held liable, because it should be very easy to find. And if it's updated, the most updated version should be online as well. So it's good to always make a copy of terms and conditions when you enter into the agreement, just to make sure nothing changed afterwards. So what happens if delivery is done on time, but the payment delays for months? So yeah, this could be another problem, especially if it's about money. If the payment is delayed for months, well, first of all, I would like to know, why is the payment delayed for months? Is it because the other party is not able to pay? Because then maybe we can offer to pay in installments, so there is still some cash flow ongoing. But we can also suspend our delivery, because maybe we need the payment in order to deliver the product, right? So for example, maybe everything is tailored and we can only create the product if the payment is fulfilled as well. So if the other party is in breach because the payment is delayed, it's basically a breach of the agreement, because payment terms are usually defined in the contract. Then we can also tell them we're not able to continue delivering either. Also, I think a student is saying here, I think we can stop paying if we receive wrong products. Well, it depends. If you received wrong products, you can usually send this back to the supplier, because they should be able to send you a product that is according to the terms of the agreement. So for example, if you are going to buy a camera and the camera is not working, you can send it back, because it's a malfunctioning product. So it should be delivered on the exact same conditions and what you can expect from such a product too. So this is important to think about as well. So be careful if there is anything not clear about specific delivery dates. It can cause delay, even if the delivery is not delayed. If the payment is going to be delayed, it can still cause a delay in the performance of the agreement, because the other party feels the relationship is not trustworthy anymore, and they don't feel like they need to perform under the agreement anymore, and it can also increase your costs a lot. So be careful here. Also, another question is, what could be a problem when you work with milestones? We spoke about the advantages before, but what could be a problem when you work with milestones? Does anyone have any idea? Again, thank you for your input about delivery terms because it can really impact companies negatively and it can lead to misunderstandings, delays, and even lost sales. So it's really important to think about clear terms. And thank you for sharing this with everyone. It's important information. So do you think if we work with milestones, could there be any problem, or is it always better to work with milestones? I don't see, I see a hand raised here. Rose, can you share your thoughts with us? I am trying to unmute you. Rose, can you hear me?
Yes, madam. Hello, madam.
Hi, Rose.
Yes, madam. Hey, wait. In case you must ensure that the project milestone is fulfilled. If the project milestone is not fulfilled, it means there will be a delay in the delivery. So the parties must ensure or must enforce the party must ensure that the time or the milestone or the project milestone is achieved. Otherwise, if it's a project and there's a timeline for the project, it means if the milestone is not achieved, it means the project will delay. So they must ensure that the various stages of the project is fulfilled. Hello?
Yeah, Rose, I'm listening. Thank you for sharing your answer.
Yeah.
So you were saying that the project could be delayed and there's a timeline as well that should be really important if you work with milestones. Is that correct? It could be delayed. That's true, Rose. But
Yes,
it can also
madam.
be it could also be more beneficial for you if you have clear milestones and they're reasonable. So we have a couple of other answers here I would like to share with you. Somebody is saying it's better to work with milestone because of big money or in big investment needs big control. That's true. So actually it can work against delay as well if there is a big investment. It could be more balanced if it could be more balanced. So what could be a problem? Well, the problem here is there could be non-payment. So like I told before, if there's only one milestone, there could be a huge risk of not getting paid at all. So if there's going to be a milestone, please check if we can agree upon minimum 2. And then also, if you work with milestones, then when is the product finalized? So if we have the final milestone and the final payment, are the terms clear when we can expect a final delivery? When is a delivery final? So for example, does the other party approve the product, or do they have 1 week to review the product and then they can give us feedback, or when is it finalized? So make sure at the end of milestone payments as well, what are the terms and when do they have to pay the final milestone? Because it's finalizing the payment structure. So I think because of the time, we have to proceed with the final sheets. Rose, I hope this answered your question. So if we speak about payment terms, we can prevent non-payment risks because we can work with milestones, for example, but we can also work with a different payment structure. It depends on the type of agreement. So I think we discussed this now. And also, if we think about offer and acceptance, we discussed it in the beginning. If I will create an offer, the offer must be accepted, right? So if I will only send an offer, which is not accepted yet, there is no binding agreement. It should be very clear that the offer is qualified as accepted. preferably in writing. If it's verbally, it can lead to discussion afterwards, so preferably always put this down in writing. So another example here is if we have a European-based manufacturer and they're going to work with a company in the States, they could define New York as the governing law to avoid jurisdictions issues. What else can we think of here? Is there any other type of provision we could maybe add in this agreement to protect us better in the event of a problem? So if I have a European company, you are located in New York, we say the state of New York is going to be the governing law. What could help us if we have a problem to move forward faster? Is there something we can think of and agree on together to move forward faster and maybe pay less amount of money, hopefully, as well, to resolve our problem? We spoke about it during this lecture, and I'm going to give you a tip. We can think about ways to resolve a problem through different types of methods, basically. So what we can add here is, for example, we will do our utmost best to resolve the disputes amicably, which means directly between the parties. If this doesn't work, we can also appoint somebody to act as our representative, and they will enter into negotiations on behalf of us. We can also think of mediation, like we discussed earlier today. If we appoint a mediator together, this is always a neutral party. They're not going to pick any sides. They will negotiate with both parties, and you will both share the cost. So this can go much faster. They can work with you in your own language, and both parties will share the costs. And we can think about arbitration. So if you have a cross-border relationship, you might want to think about what will happen in the event of any problem. How are we going to resolve this? Because you can save a lot of money here if this is clear defined. So always try to have clear disputes resolution options, which means there's a clear method for both parties. If there is any problem and you are not able to discuss this anymore directly, what are you going to do? Because litigation can be very, very expensive and it can be utmost time consuming. So I would like to thank you for today. Thank you for attending this class. And I would like to save some time to answer any questions you may have.
All right. We have a question from Ali MD.
Hello. Hello, sir.
Hi,
Good
Aliam.
morning, sir.
Hello, hello. We can hear you.
Hello, ma'am.
Hello.
Hello. Hello.
Hi, I can hear you.
Hello.
Please proceed.
Can you hear me?
Yes, I can
Can
hear
you
you loud
hear
and
me?
clear.
Uh,
Yes, Ali, go ahead with your question.
Offer and acceptance. Offer and acceptance must be. If offer and acceptance is not clearly described, what can be a problem? If a party offer, but other party do not accept the offer, what could be the business situation?
So Ali, I hear the second part clear, but not the first part. The question is if there's an offer, but the offer is not accepted. Or Dr. Lambert, can you help me, please?
Yes. If other acceptors do not accept the offer, it is legalized. Can it be legalized?
If the offer is not fully accepted, or maybe it's not accepted in a very clear way, well, then there's going to be an argument about it because it's going to be more difficult to prove there is actually an agreement applicable in this scenario. So if you, for example, have an offer and the other party accepted this verbally, but there is no other type of behavior or communication that made you to expect the performance of the agreement, it's going to be more difficult. If you have more pieces of evidence, pieces of proof, for example, maybe they accepted in an email, a very simple email, then it could still be enforceable. But if it's not detailed, if it's a very brief offer and it's maybe only a couple of sentences, yeah, then there could be a gap in the agreement because it's not very clear what you can expect from one and another.
Before we go on, I have a question that I know many people have. When a person is working for a company or the government, but they don't receive their paycheck, and maybe 3 months, 6 months go by and they still continue to work, but they don't receive any pay, what do you recommend for that person to do?
So if they did get paid, Dr. Lambert, but they didn't receive the pay slip or they didn't receive payment at all for the past 3 months or 6 months,
Exactly, that didn't receive payment for their work.
they didn't receive payments for their
And like
work,
they're
that
still waiting for it.
that's a huge problem. Well, if you didn't get paid for your work, you can at some point you can tell them you're not able to perform the work anymore because you need the money, for example, to commute to work, for transport to go to work. If they need to pay you for your work, you can hold them liable, but it should state in the agreement as well. The terms of payment, you can expect this every month. And also check if they're able to pay, because if this government party is not able to pay you or they could be corrupt, for example, it could be a huge risk for you to work with them. And it really depends on these scenarios. So for example, if a government entity or like the specific body is not paying you for the past 3 or 6 months, they are liable, and sometimes they should pay a bit more because um, yeah, it's a late payment, but it depends on what type of agreement. Is it business to business, or are you an employee working for this governmental body? Why they did not pay you? Do they have money problems, or yeah, what's the cause for non-payment? And for how long have you not been paid? If you didn't get paid for 6 months, it's a serious problem.
So when do you think a person should sue for their back pay?
Well, if it's 1 month, then for example, if they didn't pay you for 1 month and they pay you 2 months afterwards the full amount, then I wouldn't start suing them straight away, because if it's a party with financial trouble, then maybe they can pay you over time. But if from the government, you should be able to expect timely payments. If they didn't pay you for the past 6 months, then I would definitely speak with a lawyer in your own country and check your legal rights and sue them, because you are entitled to receive payment for the work you have performed, because you already performed the work as well under the agreement and you did not breach the agreement. You have been performing as was expected, and they should pay you. There is not a reason for non-payment apart from when they go bankrupt, for example, but this is the government, this is not an entity. So I would recommend you to definitely consult with a lawyer in your own country who knows the specific law applicable and the government, because if it's a corrupt government, I'm not sure about the countries we are speaking of right now, but if it's a corrupt government, it's going to be much more difficult to enforce your rights. So that could be that this could be a huge risk for you, unfortunately, because sometimes even some courts in countries, they are um, corrupt, and it will
So
be very
that's kind
difficult
of,
to fight it for your rights.
it's similar to what can happen in a business to business contract too, right?
Correct, but for business to business contracts, if they go bankrupt, for example, it's going to be very difficult to get the money. If it's the government, um, the government should pay you on time. The government is not really going bankrupt like an entity, right? So, and if you work for an entity as an employee, it differs per country. So, for example, the Netherlands, we have very strong employee protection. Other countries, like Egypt, for example, it might be more difficult to enforce your rights. So it The answer to this question can vary per jurisdiction, but if you do not get paid for something you have delivered, you should consult a lawyer because you have legal rights. And if you perform the work as was expected, you should be able to receive the money accordingly.
Okay,
It's not okay to not pay you.
let's go to Elvis with the next question. Thank you so much for that.
Thank you, Professor Lampard and Attorney Lynette D. My question is quick. Thank you for that quick presentation. My question is, in terms of different jurisdictions, if you have a dispute arising from different country, this is business to business contract, but is people from different countries, how is the law done? How do you approach such a scenario?
Yeah. So, for example, if there are different entities involved from different countries, I would choose the country that makes the most sense. So, for example, if I'm going to be the biggest party under the agreement and I am going to create glass products, I would most likely ask to have the governing law of my own country because I am creating a lot of products and I'm going to deliver to different entities. It depends as well because if, for example, 3 parties are located in one country out of the 4 entities in total, the parties most likely will agree on Dutch law. You basically can agree on different types of governing law, but there should be a link. So usually you choose the governing law in which one of the entities is incorporated. And for example, if I'm going to deliver the products, then the governing law will be the one of my own country because I am delivering the products to your company. And I'm creating them as well in my own country. So this is how you approach the governing law. So you think of, okay, which governing law is applying here? Where are the entities located? Is it civil law? Is it common law? Which countries are involved? And what can we do in case of any problem? Is there a way we can resolve the dispute in a faster way, which might be less expensive?
So because so in terms of the courts that handles business matters, because I'm sure you not go to international criminal court just because of business. What which court normally handles such cases of business to business involving different
Correct,
countries?
Elvis. You could go to the criminal courts though if a party is committing fraud. So, for example, if they falsified the papers, then you could still go there. But that's a side note. Well, there are different institutes for like business disputes. So, for example, if you check the United States, Delaware, for example, has a very specific business center that only handles business disputes. Switzerland, they also have a arbitration center. The UK has one, which is one of the oldest ones, and they have a lot of expertise. So I would check the countries that are involved under the agreement and who you're going to work with, and which country could maybe offer the best expertise for the parties involved.
Okay.
And you can check this online.
Okay. Awesome. Clear explanation. Thank you.
Thank you so much, Elvis.
Very welcome, Elvis.
Ismail.
Thank you, sir. Good morning, sir. Yeah, good morning, Dr.
morning.
Davison. Thank you. Thank you for the presentation. You have mentioned a lot of the whole thing. Yeah, but for the sake of questions, let me put it this way. For the both parties to minimize risk and establish a solid foundation for a successful business-to-business relationship, my question is this. How can businesses negotiate favorable terms and conditions in business-to-business contract without jeopardizing the relationship with the other party?
Yes, that's a very good question, and thank you for joining today. First of all, it's a good question you ask, and I think this is important for all of us. The way you can negotiate this is there is always a certain minimum the other party is willing to agree upon, because sometimes they cannot agree on something below a certain level because they need a certain level of protection or certainty because of finance. So try to figure out what are the risks of the other party, and if they would like to amend a specific provision, what is their objective, what is their reason behind it. Usually if you work with another party and they have some input or they are willing to agree on different terms, you can always ask them if they propose a amendment, which basically a provision that has been changed. You can ask them for the reasoning behind it, because usually there is a reason why they are asking you to agree on different terms. It could be because of the law that's applicable, but it could also be because of their own situation. So, for example, maybe the other party is simply not able to agree on this because it would impose a huge financial risk and they could go bankrupt. So, check if they are able to commit to the terms as well. Usually, you try to negotiate the most fair way for both parties involved, because if you want to foster a long-term relationship, you try to understand the other party and where they're coming from as well, and what could be most beneficial for both parties involved.
Mm.
So Lynette,
Mm.
if you're
Thank you.
doing terms of payment, do you recommend 15 days, 30 days, 90 days, or just negotiate that with individual suppliers or distributors?
Good question, Dr. Lambert. Like, it's quite typical to agree on 14 days or 30 days. That's most common. But sometimes they agree on longer terms for payment because the other party needs more time to receive the payment, or they have a corporate structure and they have different terms applying for all entities. So it can differ per party that is going to sign the agreement. Usually 14 days or 30 days are common and reasonable, but some parties, they would like to opt for 60 days, for example, because they need more time to collect the money and then they can pay. So it depends on the party being involved and what is what's realistic for them to commit to under the agreement.
Now,
Yeah.
in some
Thank you.
countries, you actually don't have enough
Yeah.
currency moving through the economy very fast. So it kind of makes more sense to have a longer payment term because money doesn't move very fast.
Yeah.
But at the same time, you need the money faster to keep the money moving, right?
Correct, especially when you're investing in it, or when you're building a specific prototype, for example, or a product. Sometimes you do need the money. So you always have to try and discuss with the other party what you can agree upon, because if they would like to opt for, let's say, 3 months, it might not uh, it might disable you from performing under the agreement. So you might not be even able to enter into this relationship because you are not able to provide and create such a product because you need the cash flow from the other party. So that's why it's always important to understand the other party a bit better, so you can know what's their minimum level and what they are willing to agree upon at the minimum to save
So
back and forth.
so if a party knows it really can't pay for 90 days, but it does a 30-day agreement just to get the contract, is that illegal?
Well, it's not according to what's happening in practice, and if you know it's not the reality, it doesn't really make any sense to put in 30 days if it's actually 90 days. So that's something I would not agree upon, because then the other party could be in breach under the agreement, whereas they told you verbally they need 90 days. So that's something I would not consider to put in the agreement.
Well, it's just that they know they're not going to be able to pay in 30 days, but they agree to it
Yeah.
anyways. Is that because they know it's going to create a problem because they're not going to pay on time, but they say they will? Do you have to
Then
prove
they
that?
are in breach of the agreement. So if they are not able to pay in 30 days, they are breaching the agreement. So then you can tell them we're not able to deliver under the agreement either, and there is a dispute going on. So that could be a huge problem. Actually, if you know you're not able to pay within 30 days and you're still signing such an agreement, you will not be trustworthy for the counterparty either. I think it's really better if you are transparent and tell them about the situation, because if you can explain to the other party you need more time to collect the money from your clients, or this is the structure that the group of companies your entity is part of, they always work like this, maybe the other party will understand and agree on a longer term.